So the Supreme Court has broken our political system. Check this out. Leave your comments, ding the bell, share it with your friends, and please subscribe to our channel. Apparently, the grifter in the White House is making billions. Somebody, and we don't know who, but somebody is buying these highly leveraged stock devices. They're basically bets on movement in the stock market, but they're highly leveraged, where basically if you lose the bet, you lose everything that you put up. But if you win the bet, you win big. And whoever this is keeps buying these rather conspicuous chunks of this particular type of stock bet just before Donald Trump says things about how wonderful everything is with China, or we just reached a deal. In fact, in one case, he actually lied through his teeth. Just made it up. Yeah, we had 2 phone calls from China. There was a bet out there. That bet paid off, and as soon as the bet paid off, Trump was like, oh, no, I lied. So we're going to ask Richard Wolff about that. Also, we're discovering that Donald Trump had 2 sets of books. It's becoming quite clear, and New York City is investigating this. He had 1 set of books that showed that his companies were losing money, and therefore he shouldn't have to pay property taxes and other kinds of taxes. And then he had another set of books that he showed to bankers and investors and potential condo buyers, saying that he was making money hand over fist and things were wonderful. This is the definition of financial fraud. And we're going to get into that in our second hour with Professor Wolff as well. And as I mentioned in our third hour, Joe Madison is going to drop by. We're going to talk about Elijah Cummings. But in this first hour, I want to get into the Supreme Court because there's just like so much happening at this level. One of the circuit courts, I believe it was on September 23rd, and I think it was the Third Circuit, recently struck down ownership rules of radio stations, some of the ownership rules, making it easier for billionaires to buy lots and lots of radio stations and put lots and lots of right-wing programming on them. I'm guessing probably a Trump judge. But it's just one example of, how basically the courts are running everything in this country. And so my question for this first hour is, I'll lay out the question first, then I'm going to lay out the argument, is how do we best reform the Supreme Court? Now, then comes the question, why do we need to reform the Supreme Court? And there's a really fundamental question here. And that is, do we live in and want to continue living in either a constitutionally limited representative democratic republic or a constitutionally limited monarchy, a semi-democratic monarchy? Now, in a monarchy, you've got somebody who is not elected by the people, who is not answerable to the people, typically the consequence of accidents of birth, right? The son of the previous king, or the daughter if there are no sons, as in the case of the Queen of England right now, or if a son decides to, step out of the line of succession or whatever. There's all these variations, but basically, somebody who's not elected to office, who has final say on everything, who can, shoot down laws, who can, dissolve parliament, things like that, who can decide who the leaders of the country are going to be. That's a monarchy. And that's a role that the Supreme Court filled in 2000 when they decided that George W. Bush would be the guy who would be in the White House. That's the role that the Supreme Court fills with almost every decision now, striking down, upholding, modifying, or rewriting laws in case after case after case. And this is a process called judicial review, using your interpretation or understanding of the Constitution to decide if you're going to allow a particular law which has been passed by Congress and signed by the president to stand. And there is arguably nowhere in the Constitution where the Supreme Court is given this power. It just doesn't happen. And in fact, in the early, it's just not there. In the early days when the the whole issue was being debated. You know, what are we going to have here? How is this going to be done? The Constitution was written in 1787. In 1788, Madison and Hamilton published this long series of newspaper articles to basically sell the Constitution. And I'm reading, this is from page 16 of my book, The Hidden History of the Supreme Court. This is from the chapter, The Hidden History of Judicial Review. May 28, 1788, Alexander Hamilton in the Federalist, quote, and the problem was people were worried that the Supreme Court, would end up being a monarchical branch of government, that they would end up being basically in charge of everything. And he says, the judiciary is beyond comparison the weakest of the three departments of power. It can never attack with success either of the other two branches. Well, clearly that's no longer the case. He says, he's quoting Montesquieu, he says, of the three powers above mentioned, the judiciary is next to nothing. He said, this is Federalist 78, from the natural feebleness of the judiciary, it is in continual jeopardy of being overpowered, awed, or influenced by its coordinate branches. But then again, these voices, particularly people like George Mason, kept coming up and saying, and Patrick Henry, saying what would prevent the Supreme Court from rising up and taking over the country. And so in June of 1788, in Federalist 81, Alexander Hamilton addresses that. And he says, the argument, or rather suggestions upon which this charge is founded, in other words, the things that, like Patrick Henry was saying, the Supreme Court's going to be too powerful, are to this effect, that the authority of the proposed Supreme Court of the United States will be superior to that of the legislature. The power of construing the laws according to the spirit, and he has the word spirit in all caps, of the Constitution will enable the court to mold those laws into whatever shape it may think proper. And then, so he's quoting basically the argument against the Constitution, against the Supreme Court. And he says, this is as unprecedented as it is dangerous. And then he goes on to speak right to it. He says, in the first place, there is not a syllable in this proposed Constitution, he says, in the plan under consideration, in the proposed Constitution, which directly, the word directly in all caps, empowers the national courts to construe the laws according to the spirit of the Constitution, or which gives them any greater latitude in this respect than may be claimed by the courts of every state. And, he goes on from there, and in fact, I could read a dozen more, but I'm not going to. So what happened? Well, up until 1803, the Supreme Court basically was the final court of appeals. I mean, they were a primary court for disputes between the states and stuff like that, but, their principal function was being the place where the buck stops. But in 1803, the Chief Justice of the Supreme Court, John Marshall, who was Thomas Jefferson's third cousin and bitter political enemy, which is why John Adams made him Chief Justice of the Supreme Court on his last day in office in March of 1800, as he was having to turn over the reins of power to Thomas Jefferson because Adams lost the election and Vice President Jefferson became President Jefferson. So 2 years later, Jefferson's third cousin and hated political enemy John Marshall strikes down part of the Judiciary Act of 1789. And by striking down a law passed by Congress and signed by the President, asserts that he, as Chief Justice and the Supreme Court, have the power, have a superior power to that of the White House, the presidency, and Congress. And Jefferson went nuts. He said, if this decision stands, the Constitution has become a suicide pact. Under this construction, the court is now a despotic branch of government. He wrote to Abigail Adams. He said, who was a friend of his at the time, even though he wasn't talking to her husband, he wrote to her and he said, under this, the Constitution has become a thing of wax to be molded in the hands of the judiciary. So, Marshall got his fingers burned. He didn't do this again for the rest of his career in a big way. No more judicial review. The next time it happened, the second time it happened in a really consequential way, was in 1856 when Chief Justice Roger Taney thought, I'll solve the slavery problem once and for all. And in a decision called Dred Scott v. Sanford, ruled that the federal laws that allowed for free states versus slave states were irrelevant and that all over the entire United States, people of color had no rights. They were property. And that led us right to the Civil War. So those were the two times in the first basically 80 years of the history of the United States that the Supreme Court did this. Now the Supreme Court does it every session. They're doing it with the vast majority of all of their decisions. They started this process in the 1870s when the court was being bribed by the big railroad barons. And I say that literally bribed. I wrote a book about this called Unequal Protection. We've got the letters from Jay Gould, the railroad baron, to Stephen J. Field, the Supreme Court justice from the Ninth Circuit of California, saying that he would sponsor him to run for president if he would rule in his way with regard to corporate personhood and all this stuff. So the court started being bought off in the 1870s, 1880s, and that's when they started doing this all the time. And now we've got a court that has been packed by Mitch McConnell and a series of Republican presidents committing treason to get into the White House, and that treason being accepted and embraced by right-wing think tanks and billionaires because they knew it would get them their people on the court. So how do we change the court? How do we fix the court now that this corruption has happened?
This is the Thom Hartmann Program.
And how do we even begin the discussion with the American people about whether we want to live in a constitutional democracy or a monarchy?